ruling against you. No, nothing. Like of all the choices to make in interpreting the case, they would say, I'm ruling against you in your right to present an affirmative defense. When it is one of the 4 paragraphs in the initial proposal, right? I mean, it's not just, I don't know, it's hard to rationalize it, any way that it would not be considered as an absolute, because it's, one of the 4 paragraphs. Anyway, so this is the stuff that's going on, and it was really bleak. And then, like, out of the blue, and who knew? Who knew it was going to go on? Supreme Court, like King Kalana, like 7-0. Bam! 7-0, unanimous. Like, they don't agree on pizza toppings. You know what I mean? Bam, they're all together. Like, are you kidding me? There's a Section 4 and a Section 8. Proposal said to affirmative defense. What's going on? Like, you're like, oh, my God, thank God there's the courts. You know what I mean? And, like, they were like, yeah, we're going to train. Listen, whether we like the law or don't like the law, our duty is to interpret it the way it was. I mean, it's like everything you wanted to hear. And they said, what the... And how many times did that happen? Over and over again. Like, Tariq. Well, Tariq was always that way. Tariq, I think it was like... Was it Tariq? One of them was like every single judicial judge that had a chance to vote on it voted in favor of the the ultimate outcome. Maybe Tariq, like, about I think it was, except for the There's I think Kuhn was unanimous, if not close to unanimous. Tariq was McQueen. Did I say McQueen? McQueen. No, McQueen was not. There was a dissent on that. If it's what's his face retired. Kavanaugh. And I mean, that was one where they took a swing at it. And everyone all the way along the lines missed it. You know what I mean? Right. From the district court to for the circuit court. Let's see. You got. Carruthers. And I think the only reason they didn't take that case was because it needed to be a legislative fix. But what I'm saying is, and I've talked about this, like Tim Beck agrees with me on this. The reason why I don't know if I can say this. I mean, the judiciary worked. I mean, the system worked in that regard. But I felt like there was this. For those that were paying attention, there was such an overwhelming power grab that was going on with Bill Schuette at the time, that the response of the Supreme Court was to say, read Marbury versus Medicine, you motherfucker. Right. You know what I mean? And don't, there's 3 branches of government here, and do not overstep, and, get out of here. Yeah. And that's why it's the way that it is. We are, and we may hate this law and agree that it should be legislated, but we are not going to break apart the system because one asshole thinks that it's a bad law, and it was the only one that voted against it. You got the other 3.3 million people. So I don't know. You call it whatever it is, but I think there was an element, like the energy at the time of these things going on. It was like it could be, whether it's true or not. Maybe they called the shots. The Supreme Court called the shots on the merits. It wasn't political. Nothing else. Fine, But the fact that happened and stopped what was, to me, perceived a total grab of power, someone outside of his role as Attorney General trying to influence legislature, he got command of the police force, of course. This is, and now he's just too much, too much influence on this act in every capacity. Every chance he had, to, push a button, bend a corner, make it fit here, bam, there he was, bad, terrible. And any chance another court had to assess his thoughts on it, never ruled in his favor. I mean, he was literally like 0 for 15, and everything he tried to get at regarding medical marijuana, whether it was an Attorney General opinion, no court ever, And the only case I think is that the privacy in the vehicle. He said a car is not public; it's private. In a parking lot, it'd be considered private. The police, and I agree with him. It's the only time I'll ever agree with him. But the Court of Appeals did not, and they said, it may be private for every other reason in the world, but not for marijuana. But, right?
Not in a public place. It was parked in a public
parking lot. Well, do you have a right to privacy in a parking lot?
Apparently not.
Well, for everything else in your car, you do.
A right to privacy in your automobile is greatly attenuated.
More so when you're in a roadway. Less so in a parking lot, maybe.
Public-private, I think, is where they draw the line.
No, I get it, but to suggest that someone doesn't have some kind of perceived right to privacy in their vehicle. I mean, right? I mean, there's something more than standing in the parking lot.
Brandon.
All right. What do you say? You got any Fourth Amendment comments on that? I don't know. What are you talking about? Seriously. Do you follow anything that we're talking about?
Not for the last couple minutes, no.
That's fine.
Can't lie.
That's fine. Listen, if you knew how many words that are on paper that I spoke today, it's insane. Nobody wants to think about that.
Hopefully I don't have to read those later.
That's right. All right, so let's talk about, this power grab.
Can you imagine?
What was Marbury versus Madison about again? Go. Just kidding. That's funny. That'd be really it's. I remember from college, a good case. It's a good historical case, Jeff. It stands for a really important proposition in American history and the democracy of our country, because there's three branches of government, the branch crisis, and what happened.
And the rule from Marbury versus Madison is that it's fundamentally and ultimately the province of the judiciary to say what the law is. It's the province of the legislative branch to pass the law. And it's the province of the executive branch to execute the law. So you have what we call separation of powers. And so in this case, you have the legislature wanting to go in there and tell the executive what to do, and infringe on also in the judicial power to determine it's for the courts to say what the legislature meant, not for the legislature to come in after the fact and hire some attorneys to say, hey man, we meant something else.
Well, is that for debate these days? I mean, theoretically, the legislature writes the laws,
right,
and the court interprets it as the legislature intended.
The court determines whether it's constitutional or not.
They interpret the law. They interpret the
province of the courts to say what is the law.
They interpret the law
as judicial review is what it's called.
They interpret the law
versus Madison established judicial review, and hence separation of these powers, firmly established. And so this is a power grab. The legislature is trying to usurp power from both of the other two branches by doing something they're not allowed to do constitutionally.
Explain to me how this worked out. This is almost like part of the creation story saga out of in the beginning in the Old Testament. How did the judiciary get it set up so they got to decide that they were the ones that got to decide? It's like a creation issue.
Marbury versus
That's what I'm saying. That case, but they were the one reviewing it. How did it get there? I mean, it could have been okay, get sent over to the executive branch this time.
Belief.
So belief didn't exist before that. I'm telling you, it is the immaculate belief.
Belief.
Am I right? You know what I mean?
You're right. I do.
Because it had not gotten there, and someone else had gotten to decide.
And judicial power rests on belief.
I don't know. You know what I mean? Like did they roll the dice?
We believe.
I know, but it may not have been procedurally.
We get the justice we believe in.
What if you don't believe? You get no justice? Who knows? All right, so what do we got? 9:30ish. I think went to some law stories. Anybody?
Yeah, I just spoke to Jamie, and he's going to be calling in as soon as they're done speaking. So I think we've probably got like maybe 20 minutes.
You mean you want to stop now?
No, I think you can
Okay.
spellbind us for 20 minutes.
I don't know about that, but well, we're going to talk more about separation of powers and the impact this is going to have. First of all, I don't know. It's a terrible story, isn't it? Just grab a power. I mean, I don't know. Lame duck. What is this stuff?
Well, there's a story.
Law
They're
making
going
it-
specifically after gay marriage and particularly adoption services, Christian adoption services that want to discriminate the placement of children with...
Flush that out here, because what they're doing here in this article. Did we read the article? I read the article, right?
Well, it says...
Did explain-
believe
I know,
in there,
you're right.
That's what actually...
You are right.
They're not really hiding the ball here.
They are not hiding the ball, and this grab that they're doing, as the article goes on to suggest, is that the concern is that Dana Nessel, they say, in a winning campaign for Attorney General, which means that people voted for or supported her, she said she may not defend state laws she views as unconstitutional. Which means that the people voted for her because she said she was going to not enforce unconstitutional laws, or she believed are unconstitutional, including a 2015 law that allows faith-based adoption agencies to decline working with gay residents. Same-sex couples have sued the state over the law, and the litigation remains in court. And there's a comparable principle here, which is that the faith-based adoption agencies remove children, or don't remove or won't place with medical marijuana patients or caregivers, or grandparents or patients or caregivers, just because their patients or caregivers not based upon their grandparenting or parenting, and it's based upon their religious, faith-based, religious, highly severe,
Statement of faith.
extreme religious beliefs. So the concept here is that the legislature is trying to intervene in any court case to protect the rights and interests of the state or legislature. I'm saying, am I right here? This is
Oh yeah, when I said naked, I meant naked.
oh my God! This is the fourth branch. It's the fifth branch of government. The press is the fourth. This is like this new branch is called the.
Like now we're going to tell you what we meant. You know?
Right.
It wasn't.
I'm just saying, no, they're saying we want to create some laws that recognize the idea that the state or the legislature is its own entity, different than the people, right? Like you know what I mean? Like it's like an exception in the way that we understand the laws are written, right? Like all the other laws are written a certain way, they've been interpreted. Now we're talking with some new laws for us, the legislatures. I mean,
Right, laws for.
They may try to. They may
Snakes
try to
laws, yeah.
rule. They may make a law that robbery versus medicine doesn't matter or something. These fuckers can't be trusted.
Oh, that's feds.
I know.
That right hadn't been extended to the states yet. They're going to get toasted, by the way, on excessive fines in front of the Supremes. Like Gorsuch and Sotomayor, I think they've teamed up, and Thomas is a lock. They're about
The forfeiture's
to
over?
crucify civil asset forfeiture. My prediction. Well,
When's that case heard? Are they hearing it now?
yeah, they heard it today. And those two together just laughed at the attorney. So what do you mean that this doesn't apply to the states? And while you're at it, let's have a look at like whether this was reasonable or not. And it's just like said, really? Or basically said, you making this argument that this guy really?
Oh my God! Let's play that. We're gonna cue that up. What's going on there? That makes me happy for a moment.
Watch.
And that's what case that's out of New Mexico?
I don't remember.
If I recall, because the state's right issue, right? Because the state of New Mexico had, I don't know, the state of New Mexico had banned forfeiture, like hydrated foods.
For some reason, I wanted it was Indiana or something. They took away this guy's $40,000 car for a drug offense or something like that. That had a maximum $10,000 fine, and he said that was excessive fine. Challenged the forfeiture laws as excessive fine, and now they're about to say, "Damn right it was," and really going to blow a hole in the whole civil asset forfeiture. Watch this. Alito and Roberts were the only ones that were kind of law and order, according to sources.
Do you guys want to criticize Josh's comments in the newspaper? See if we think they're appropriate,
Yes,
and if we would have approved them. Yeah, you can get in on this. This will be fun. Go ahead. So,
Oh, did Steve show you the envelope he addressed today?
no.
Ask Steve tomorrow about it.
Okay.
Definitely.
Yeah, where is Steve? He was supposed to be coming back.
He is after his soccer hockey game.